Councilmember Gary Edwards. And city staff, we have our city manager, Carol E. Givanato, Gay Johan, who's a city clerk and assistant city manager, and our attorney, Jeff Walter, who I will let begin.
Thank you, Mayor. Can everybody hear me? Welcome. This afternoon's gathering has one purpose, and I thought it would be important to remind ourselves of what that purpose is. The purpose is to go through proposed amendments to the city's existing rent control ordinance. Today's purpose is not a generalized discussion about the pros and cons of rent control or rehashing or revisiting relationship issues between the park owners and the residents, or talking about affordable housing or expanding rent control to other portions of the city besides mobile home parks. Those are important discussions, but they need to be reserved for another day. This is a continuation of our April meeting where we left off after hearing extensive discussion and public testimony about the proposed revisions to the ordinance. And today, it's the council's turn to ask questions and give direction to the city staff and our office as to what it wants to do next. Which of these amendments is the council interested in pursuing? And if there are any, then our office would be given direction to draft up an ordinance to come back to council for introduction at a future meeting. So that's the focus of today's meeting. And it's been structured such that you all will be able to hear the exchange, the deliberation, the discussion, the points made by the council, the questions asked, and the straw votes it makes as to the various points of decision that are set forth in the decision matrix that it has before it. This is the decision matrix that was prepared for the last meeting. One item has been added to it, and I'll talk about that when we get to it. But this is, in the main, the same matrix that was before the council several months ago. So we're going to go through that and talk about what the council thinks is appropriate with respect to amending our existing ordinance. Just to give you a brief background on the legal setting that we find ourselves here in Sonoma. The legal setting in terms of rent control is that the city has a rent control ordinance. It was adopted in 1992. It controls rents at mobile home parks. It froze rents that could be charged for space rentals to the rates that were in effect in 1992, because that was the last year that park owners could choose whatever rent they wished to assess the park residents. Thus, the presumption is that those were market-driven rents and that they were providing park owners a fair return on their property, which is the constitutional standard that governs all rent and rate setting in the United States. Property owners are entitled to a fair return on their property, and people in the position of regulating those kinds of rates and rents must keep that in mind and must make sure that that kind of return is provided to the park owners and the private property owners. Those frozen rents can be adjusted in several ways. The first way that they are adjusted is through the annual automatic increase that every park owner is entitled to take advantage of. And in Sonoma, it's 80% of the change in the CPI for the previous 12-month period. Another way that those frozen rents can be adjusted is by a petition to the Rental Review Board asking that the base rent, which is that 1992 frozen rent rate, can be adjusted on the basis that the income for that particular year, 1992, was disproportionately small or expenses were unusually high. There's not been such a petition during the time I've been the city attorney over the last 5 years, and it's probably practically too late to seek such an adjustment at this time, but no such petition is currently pending. A third way that the rates can be adjusted is by way of a petition filed by the park owners seeking to increase rents to assure them that they are getting a fair return on investment. So they would be arguing that the annual increases are not sufficient to assure them that they are entitled and are receiving a fair return on their property. That is a third way to increase rents, but those increases can only occur after a petition reviewed by the Rental Review Board. The last way that rents can be adjusted is through a pass-through. Again, by petition, the park owners must obtain approval of an increase in rents to cover the cost of necessary capital improvements. And the city's resolutions and regulations set forth how many years certain kinds of improvements must be, how many years those improvements are likely to exist and to be effective and useful. And during that period, which is called an amortization period, the rents in the park can be increased to cover the cost of the capital improvement involved, plus interest. Once that was the subject of a Rental Review Board hearing in November of last year. The Rental Review Board denied the request for an increase to cover capital improvement cost, and the city is in litigation over that issue at the present time. Several years ago, a group of residents retained an attorney who proposed and prepared various amendments to the rent control ordinance in the city of Sonoma. And it's those proposals, as well as some that have come forth by the park owner's representative, that the council will be considering this afternoon. The most significant change that the residents are proposing is to do away with the Rental Review Board and instead to replace that one-level hearing procedure with a two-stage hearing procedure beginning with the city manager. So the current proposal by the residents is to have the city manager make decisions about the various adjustments I've just been discussing by herself, with the aid of experts. If that decision is deemed unsatisfactory to any party, that decision can be appealed to an administrative hearing officer. The proposal is to use the State Office of Administrative Hearings to handle that. And that office has a variety, or not a variety, a number of typically lawyers who act as hearing officers. And at that hearing would be the appeal of the city manager's decision. A full-blown hearing would take place at that stage, and then that decision would be the final decision on the issue at hand. If a party was dissatisfied with the hearing officer's decision, then that party must initiate litigation challenging that decision. So I'd like to begin with that issue with the council. And that's the first question on the matrix. The question being, is the council in favor of doing away with the Rental Review Board and instead utilizing a two-stage hearing process beginning with the city manager? I think that you can save let me tell you how this is structured today. This is pretty much going to be a discussion between me and the council, and to the extent I don't have answers to questions asked, then I would invite the council to look to the audience for those answers. But until that happens, I think we need to move forward. We have a lot of decision making to do today. We only have 2 hours, and part of the 2 hours has been set aside for public comment. We thought it would be most advantageous to the public to do the commenting after they've heard this dialogue, so that if you think the council's gone down the wrong direction, or you think I've given improper or inaccurate information, that's the time to bring that up. After that public hearing portion is done, then the council will reconvene, and with that new added information will give me additional direction. So that's how we're going to proceed today.
Thank you, Jeff. So with that, I did want to tell public that this is a meeting of the city staff with the council. There'll be times that we are talking back and forth to city staff. We apologize if we're not looking at the audience, but this is a meeting that is being taken place with public attendance. With that, is there any colleague on the council that would like to start discussing issue number 1? Vice Mayor Gallion.
I have gone ahead and reviewed this, and I say that I am in support of going ahead and disbanding the Rental Review Board and enacting the new process. Is that the type of input you want?
Yes.
Thank you.
Councilmember Hunley?
I have a question. So there seems to be disagreement with how useful the Office of Administrative Hearings would be. Can you give us your opinion on that now? Or is that something that we would talk about in closed session?
I think we can discuss that now. I've been before that body maybe 3 or 4 times in my career. I think that by and large the hearing officers are intelligent and understand the issues at hand. And I think that's the most important part. There's no guarantee that any arbitrator, unless you get a pool that have dealt with rent control before, and there's not a lot of arbitrators who have. It's a very complicated area and fairly esoteric. Generally, I don't have a problem with using the state office. It's fine. It's been set up to handle a variety of issues. They have been primarily involved in personnel matters, labor law issues, but I know that they're used for other issues as well.
Councilmember, or Vice Mayor Gallion?
I also wanted to add that it is my my direction to go towards the state's Office of Administrative Hearings for dispute value.
Councilmember Agramonte?
It's interesting. I actually looked up the organization, and it's very involved to serve, and there are many judges within this, and there are 5 divisions: general jurisdiction, special ed, Department of Development Services, public works dealing with contract arbitration, and teacher reduction and force proceedings. So the areas of responsibility are varied, I found, and looking up some of the cases. So I'm very satisfied. If you don't mind, at this time, I believe in disbanding the Rental Review Board and assigning the responsibility to the city manager, and I'm very comfortable with state's Office of Administrative Hearings. And I would imagine when it says here, whose decision is based solely on experts' evaluation, I would imagine they're going to be looking at those 4 things that you just mentioned to be able to judge on, to be able to make a decision on what you've just mentioned, the 4 things.
Yes, and that's sub A, B, and C, because the residents' proposal has addressed itself primarily to fair return hearings. And fair return hearings are hearings that respond to a petition from a landlord seeking to increase rents to make sure they're receiving that return on the value I talked about earlier, a fair return on the property. That's only one way to adjust rents. I'm suggesting that if the council is supportive of this structure, that it be applied to all ways that landlords can increase rents, as well as to those petitions filed by residents who believe rents should be reduced because of a reduction in services. So the entire hearing process would go to the city manager initially under my vision of how this would best work.
Hunley?
And as far as the expense of it, how does it compare to, say, going through the Arbitration Association or JAMS as they've suggested?
I don't know.
Gallion?
So the question would be just in some of the issues as far as the pass-through is concerned. So for me, I'd like to be hearing a little bit more about the amortization process and, you know, how others are feeling about, you know, that particular issue. So I don't know that I'm prepared to speak on at least B and C. I am in support of A.
Edwards?
I'm going to support disbanding the Rental Review Board. The infrequency of their meetings over the past several years and the length of service, which I appreciate from the folks that have been on it, but I believe it's going to give us, give both sides actually a better venue to make their claims.
And in response to Council Member Hunley's question about costs, the way this is structured is that the parties involved would be paying the costs of the hearing officer, whether it's JAMS or the state office. The city would not be picking up those costs.
Hunley?
I agree with Councilmember Edwards, and I believe that we should disband the rental review board and have the process go through our city manager for all three, A, B, and C. I think that that's going to take a lot of the emotion out of these decisions that really are just based on crunching numbers. And I'm also comfortable with using the Office of Administrative Hearings.
And I also would like to disband the rental review board, give the responsibility to the city manager going through the state's administrative hearings. And I see that we have a yes with 5-0 up here on number 1, which goes to A.
Yes, let's chat about whether you would like this process to be applicable to the fair return petition.
Yes, for me.
Yes.
Yes.
Yes?
And also I am yes, so that would be a 5-0 on fair return petition, number A.
And in terms of B, the service reduction petition,
With work that I've seen the city manager do in my short time on council and previously with planning commission, I believe she's got the capabilities to make fair assessments, so I'm going to support B as well, as a yes.
Yes.
Yes as well?
Yes?
And also I would say yes, so we're a 5-0 for service reduction petition. And if it's okay with my colleagues on the council, we'll keep going down this way with Edwards Hunley. If you do not want to speak, just say pass, and then we'll come back to you. So that takes us to C.
again, the capital improvement pass-through petition is a petition brought by a park owner seeking to obtain rent increases to pay for specified capital improvements. Replacement of a street, for example, replacing a swimming pool, building a new community room. This needs to be something other than a maintenance or repair item, and it needs to be something that is typically long-term in life and usefulness, replacing a sewer system, replacing the electrical system, replacing the water system, upgrading the water system. Those kinds of capital improvements cost money, and the rent control ordinance allows the park owner to apply for a rent increase for those costs. And the way that they would be paid for is that the city's regulations currently provide for different kinds of periods of time over which those increases would be allowed. So let's assume we're talking about building a new community room, and let's assume that the city's regulations identify the useful life of a community room or structure of that sort to be 30 years. The landlord would be entitled to a 30-year rent increase equal to the amount of the improvement plus interest. And then that amount would be divided by the number of residents who benefit from that community house and are regulated by rent control.
Jeff, how would that interest be determined?
The city's curtain code refers to interest rates specified in a particular document that I do not recall. I think it's the Wall Street Journal. And so there's a place to go to identify that interest rate.
So again, that would be considered expert in that respect, and that's what it would be based on.
It would. The park owner would come forth with his or her, its contractor, an estimator, a variety of experts and reports to show that it is necessary. It's not an issue of maintenance or repair. The city, in response to that, under the proposed ordinance, would be entitled to retain an expert or experts to examine that claim and to file their own report and to give advice to the city manager to respond to that petition for a capital improvement pass-through. And then the city manager, based on the experts, the war of experts, would decide what the amount, if any, should be to increase the rents to pay for the capital improvement.
And then, not to confuse that, but the experts, would the cost of the experts, which is either going to be paid by one party or another, the amortization of that particular fee, would that be a different rate than it would be the actual capital pass-through rate?
I don't know. I don't think it would be different.
Okay. This is some of the discussion that I would hope that there would be clarifying language concerning.
Yeah. There are going to be some of those questions I won't be able to answer because I'm not totally clear on the intent of the legislation that was drafted by the residents. I've got a pretty good grasp of it. But the proposal is that the city would be able to charge the park owner for the cost of those experts. If the park owner is successful in its petition, then the cost of those experts would be recouped to the park owner over a 5-year period with interest.
And that's what I was referring to. It's a separate time period other than, say, a capital improvement.
It would be.
And I would be amenable to that particular language in item C,
With modification?
with clarifying language of that nature in item C.
Edwards?
So with item C, considering the city manager, that's what she does, are capital improvement projects. I think it's going to save both sides time, effort, and money to have that part of the reviews.
So what's the oversight side of things? So they apply, they get approved for a capital improvement, as far as verifying that the rents are accurate and then verifying that the project's actually being done? Where does that fit into this?
The current ordinance, and it would be, we would borrow from some of the current ordinance for sure. The current ordinance says that the rents cannot be increased until the capital improvement actually is completed, and a certificate of completion is provided to the city. So even if they get permission to increase rents, if they never do the capital improvement, they'll never get the rent increase.
Okay. I'm amenable to 1C.
Gallion?
Yes, I did say yes.
Yes.
And I would also say yes to C on the capital improvements, which leaves 5-0 with the council, with some clarification on Vice Mayor Gallion's, which now is number 2, authorizing the city manager to retain experts to assist the city manager in making decisions on individual rent increase applications and requiring the applicant to advance funds to pay for such experts. It appears that the proposed revisions allow the applicant to recoup these costs in the form of rent increases if the applicant is successful in achieving the results sought in its application.
This covers the issue of whether or not the city should charge the park owner for the costs that the city incurs in processing and investigating the application submitted by the park owner. Mr. Yassine has argued long and hard that this is a violation of his client's rights to petition the government to redress grievances and violates the Constitution because it chills his client's rights. He cites several cases which I do not think are germane. The principal case that he cites is something called the California Teachers Association case. In that case, the Supreme Court of California struck down an education code section that required teachers who were appealing disciplinary action, a right that they had by state law, to, if they lost, to pay 1/2 the cost of the judges. And the Supreme Court felt that was inappropriate. There have, however, been cases since that, also handed down by the California Supreme Court, that have ruled that the cost of processing administrative appeals and administrative proceedings incurred by the agencies administering those procedures could in fact be charged to and passed on to the applicant or this person who was subject to those proceedings. In one case, the California Chiropractic Appeals Board charged chiropractors the cost that the board incurred in investigating claims of professional misconduct. And the chiropractor brought an action citing to the California Teachers Association case and saying, oh, I shouldn't be having to pay those. That's unfair. And the Supreme Court said, no, those are appropriate costs of processing. It's not a cost for paying of the judges. It's a cost for paying for the cost of processing and investigating the claim. And there are other cases that I think that support the notion that that cities have the power to require applicants who are seeking entitlements from a city to pay for the costs the city incurs in reviewing those. Land use is classic. A person who owns property, Again, a very important right under the Constitution. Private property rights are extremely important. If they want to develop, they come to the city to apply for development. They pay the city for its fees, the cost of the city staff. They pay environmental consultant fees to pay for reports, EIRs and the like that are extremely expensive. And these have been going on routinely for many, many years. And there are other statutes that allow for attorney's fees to be paid for by the person who's the subject of administrative proceedings in the nuisance abatement context. A person who commits a nuisance is required to pay for the city's investigation costs, including attorney's fees. So I think it's appropriate. I don't think it's unlawful to require the park owner to advance the costs of the city's experts, and if the park owner prevails, then they're recouped to the park owner through a 5-year payout process with interest.
Gallion?
What is the relationship to the phrase here that says that the park owners already pay $10,000 annually to the city under the ordinance, $24 per home site? And what does this get applied to? That is in the decision matrix with DMV's positions.
Okay, total is $10,000. The city manager tells me that the $24 per resident fee that park owners pay per year pays for the city's costs in administering the program. So for example, the costs that have incurred today are in part defrayed by that $24 per resident charge. It amounts with all 3 parks to about $10,000 a year, the total amount that's recouped.
Thank you for clarifying that.
Is there any other questions before we, Edwards?
So on item number 2, I'm in favor of, I'm a yes on this one. I just left a Rotary meeting where a developer put $300,000 into a EIR and hasn't put a shovel in the ground yet. So those are upfront costs that I think that are the responsibility of the landowner.
I have one question. So as far as what the experts actually are, would it most commonly be an accountant?
In fair return petitions, yes, it will be an accountant. In capital improvement pass-throughs, it'll be a contractor, estimator, and expert in construction. So it'll vary depending on the nature of the petition.
Okay. I support this.
Gallion?
I just want to clarify that at this point with the expert fees, that is permissible to be passed through again to the residents of the parks? And the time frame that would be recoupable for?
The courts are pretty clear that park owners who incur costs in a good faith, reasonable effort to increase rents, which petition is approved successfully. If they're successful in getting rent increases and they incur costs in doing so, they're entitled to have the residents pay for those costs, be they attorney's fees, expert costs, accountant costs, etc. This ordinance, the proposal certainly recognizes that, but it spreads the hit on the residents over 5 years rather than a lump sum payment.
And I would like that clarification of 5 years also made very clear in this particular context. And then I can support item 2.
Agramonte?
I can support this with the what Vice Mayor mentioned, 5-year.
So myself, I am in agreement with this also, so we have a straw poll vote of 5-0 with some clarification on Vice Mayor Gallion, which takes us to number 3. Do you want me to say it, or do you want to say it?
I can summarize it.
Okay.
It's fairly lengthy here. This ordinance creates a fairly novel approach to dispute resolution. I think it's innovative, and I personally think it could work. It sets up a process mainly aimed at park owners' requests for a rent increase. Park owner submits its petition, and within prescribed periods of time, after the residents become advised of it, the residents have the right to submit a settlement proposal. In this context, it likely would be less rent increase than that which is being proposed by or petitioned for by the landlord. So let's assume the landlord's asking for a $25 per month increase. The park residents could, under the terms of this ordinance, submit a settlement proposal. It would be secret. It couldn't be opened by any party other than the park owner, and the residents would know about it, but the city manager wouldn't know about it, and the hearing officer in Sacramento, if it went that far, would not know about it either. They'd only know about it at the end of the final stage of the proceeding, if the park owner rejects the settlement proposal. So in my hypothetical, a $25 per month increase is proposed by the landlord. The residents get together. You'll notice this ordinance requires that a resident representative be selected. And one of the principal purposes of selecting that representative in each park is to authorize that representative to make this settlement proposal. It's left to the representative to figure out how he or she gets the consensus he or she feels necessary to bind the residents. But that park representative would be able to submit a settlement proposal. In my hypothetical, let's say it's $10 instead of $25. And let's assume that the park owner rejects the $10 offer and goes to the city manager. The city manager rules that the increase is allowed is $25. But the park residents appeal that to the hearing officer, and the hearing officer rules that the increase should only be $8 per month. At that time, the settlement offer is open to see whether or not the park owner achieved a result better than the settlement proposal. In my hypothetical, the park owner did not. And what's the consequence of that? The consequence under the ordinance is that from the date the settlement offer was rejected, or submitted, I forget which, onward, the park owner is not entitled to recoup lawyer's fees or other costs. Plus, the residents, if they retain an attorney or other experts to assist them, would be entitled to recoup those against the park owner. So there's a carrot and there's a stick. I think it could promote early settlement to these kinds of cases, and we've heard from Watsonville and the other experiences in Marina that the settlement structure, they believe, has aided in resolving some of their disputes at an early stage and costing the parties and the city less money in doing so.
Gallion?
So I have a question as far as the timing of this concern, because obviously what you're trying to do is to promote resolution within a timely manner for all parties. There's no real time frame expressed here, but maybe there is in some language that we could come up with, or maybe I'm missing it.
No, you're not at all. This summary doesn't capture the time frame. I'm going to try to find it for you.
The idea being that one is not extending to the other more time just because of a process.
Yeah, theoretically, the settlement structure it would not delay any of the hearings held before the city manager or before the State Office of Administrative Hearings. That's not its purpose, but there are timelines. I think it's the settlement offer has to be proposed within a very short period of time. Okay. I will admit, and maybe it's not an admission I need to make, but the ordinance, I think, needs to be reworked to be clearer, and that will be part of my charge. I'm struggling with it a little bit, and I have found the section. I know that you have copies of the proposed ordinance, at least on mine. It's page 12 of 29.
Oh, yeah. Starts at number 1, goes down to 12, 29. Page 20. Page 12. And it starts with number 1.
It appears, the second full paragraph says that any time after the filing of a petition covered by this part, the mobile home, let's see, mobile park or, no, that's, maybe it's the first one we covered. Maybe it's the first paragraph, the first full paragraph. Well, I understand what you're saying. You don't want this settlement process to drag the hearing process that's on its own track out. And I will make sure that if you're supportive of the settlement concept, that won't happen.
I think I was just looking for a clarification of language in that
Yeah, I don't think I
with a
could-
reasonable time
Yeah,
period.
I can't find it right off the top of my head here.
Agramonte?
Jeff, I'm sorry, I'll wait for you.
Having a hard time with this microphone. It's an old-fashioned. Okay.
So if I understand this correctly, either owners or representatives of the owners and representatives of the residents will work on this, but the representatives for the residents, they've chosen someone, but that chosen person does not bring it back to the residents. They make that decision. They've been given that authority to make a decision by themselves for everyone.
The ordinance does not address how that representative secures the authority that he or she needs. And maybe that when we get to that, we can talk about that further. But as I understand it, it's left to the park's residents and the representative to figure out how that authority gets to that representative who can then submit that settlement offer. I would suspect that it may be nothing more than the representative, we might be on the HOA board, and they have a meeting, and by writing, invite all the residents to come to the meeting to talk about the settlement proposal. And sometimes those meetings have great attendance and sometimes they do not. But if you're on notice as a resident and you don't show up, then it's hard for you to complain that something happened in your absence.
Because of it shows a lack of interest possibly.
Exactly.
Okay.
So maybe
thank
we can kick that around, and maybe you'd want the ordinance to give some basic guidelines as to how that occurs, to assure that there is notice and some form of authorization that both the city and the park owner can rely on.
Hunley?
I agree I think that's a point that we should hash out, and also, even though everyone's been united for a while and sort of pursuing this, I imagine that at some point, someday, there's going to be a disagreement, and just there be enough process to deal with some sort of disagreement within the group that we can figure out what the right answer is.
So in terms of the settlement concept that's set forth in item 3, what is the general feeling of council members regarding that?
So Edwards, do you want to?
Yeah, I mean, I like carrot and stick proposals, but I do agree with Ms. Gallion and Ms. Hunley about some sort of time frame to settle those issues. I don't know what that would be, but I'm generally in favor of number 3.
I will also give a general yes, assuming that we are going to clarify and hash out a lot of the details that we've discussed.
A Gallion? A repeat?
I will go ahead and support this as long as we have a clarifying timeline addressing a reasonable time limit not to delay any actions, and then also some interaction concerning a representative settlement time frame as well. In other words, I do not want to go ahead and put someone under pressure that they have to have a response in 7 days when, you know, they might need a little bit more time to notify the population. So I don't know if other members would agree to that, but I would like a little bit more clarification in that process.
And thank you, Vice Mayor Gallion. That's exactly what I was thinking about. I think that to benefit the owners as well as the residents, there has to be some type of a procedure, and I would like to see that worked on within this.
And myself, I agree with the clarification for time frame, not to delay, with a little bit more information on that. So for public, that was a 5-0 yes with clarification, which leads us to number 4.
Number 4 is a proposal to vest the park owner with an equal right to settle. This might arise most clearly in a reduction of rent petition where the residents believe that the park's owner, hypothetically, failure to keep the community room open for 15 months should result in some reduction in rent. This is completely hypothetical, but it gives you the kind of things that typically give rise to a rent reduction petition. Failure to properly maintain the swimming pool so it can't be used for 8 months. Typically a fairly significant amenity that's normally offered to the residents is for whatever reason denied the tenants, the residents, for a period of time. That would be the kind of thing that would give rise to a request for a rent reduction. And if in that context, the residents file a rent reduction petition seeking to reduce the rent by $10 a month, and the park owner makes a settlement offer of $5, reduce it by $5, and the tenants pursue, or the residents pursue their petition all the way to the state office, and they get a decision that reduces the rent by $2 instead of the $10. They could have taken the $5 offer from the park owner. They didn't. The park owner is entitled to get its attorney's fees and costs recouped against the residents, and vice versa. The residents are required to forego whatever costs and fees they incurred prosecuting their proposal. So it's the flip side of the coin, and it strikes me as something that is fair and equitable. If the residents have the power to settle claims or offer to settle claims, it seems to me that the park owner should be able to do the same.
Edwards?
So each of these that we're speaking of creates an incentive for people to correspond and talk and get the issues out on the table. So I'm going to be in favor of number 4 as well, because I like the idea of putting the pressure on both ways to solve these issues.
So I understand how it would apply to B on here, the service reduction, but you also have A and C. A is the fair return petition and C is the temporary capital improvement. Do those go with this proposition?
I think additional discussion should be had between our office and the proponents of some of these provisions to find out exactly how they envision them working. In the context where the park owner's applying for a rent increase, I assume that if the park owner's initial petition was for $25 and the residents came back with a settlement proposal for $10, then if the park owner came back with a proposal for $12, we would, and the residents reject that, and the park owner goes forward and nonetheless prevails, meaning that it gets $12 rent increase. We need to address how that would affect the fee splitting that goes on, would normally go on. Should the park owner be entitled to recoup all of its fees? I would say yes, if a settlement proposal came back that was less than the initial petitioned amount, but more than what the residents were willing to live with, and the park owner went ahead and prevailed and recouped at least $12 in my hypothetical, then the park owner would be entitled to recoup all its lawyer's fees and all its costs. So I think those details can be worked out in the final draft of the ordinance, and we need to flesh them out better on how each of these, because settlements are, as you know, they go back and forth, back and forth, back and forth, and trying to then anticipate each scenario and then tie these sticks payment of the other party's fees, for example, to each scenario could become a little complicated, but we would attempt to do that as long as the council is supportive of the concept and supportive of the notion that if a party makes a settlement that they eventually win on, and that the other side doesn't do any better than, that party should be rewarded in some fashion for trying to settle it, but unsuccessfully so. That's sort of the concept.
Well, I certainly generally support this whole concept, so I assume we're going to hash it out and clarify it, but I support it.
Gallion?
I would go ahead and support this, provided that I see what metrics would be determined and also any future timeline or clarifying language.
I agree.
And I also agree. So on number 4 for public, it was a 5-0 with some look at how that would be set up with that. We'll move to, you want to go through A, B, and C on that?
Well, I'm assuming that the same response would be for A, B, and C, that the notion of an alternative dispute resolution process is something that council favors, and it would be something applied to all of the types of disputes that would arise between the park owner and the tenants or the residents under the ordinance.
Okay, for public, 4A, 4B, and 4C were all 5-0 with more looking at it. Number 5?
This gets back to that annual, the representative that is to be elected and has certain powers. The portion of the ordinance that deals with this is very brief. It's on page 23 of 29 of my edition of the proposed changes. And it just simply says that the tenant homeowners of each mobile home park shall annually elect by majority vote with 1 vote per space a designated representative to receive all notices required by this chapter. The homeowner shall advise the city manager of the name, address, and phone number of the representative and notify the city manager of any change of the representative. So when we tie what powers does the representative have, the principal power, at least set forth in the ordinance, is to participate in the settlement process. And maybe we could talk just generally about what kind of procedure do you think we should be addressing or including that gives some certainty to the authority of this person. And we've earlier talked about notice of hearings where the residents would be invited to grant that kind of authority. Any additional thoughts you might have on what you'd like to see take place at each park to ensure both the park owner and the city that this person who's standing up in front of them has the authority to speak on the things that he or she is speaking on?
Gallion?
Well, it comes to that conflict of interest statement that can be interpreted in so many ways, both on a professional capacity or just by association. So I think generally, when you're doing a lot of nonprofits or corporations or whatever, you're defining what is conflict of interest. I would like to see something that actually defines conflict of interest in this particular capacity.
Well, we certainly wouldn't want their residency to be a conflict of interest.
No, that's not being it, but,
Yeah.
Perhaps maybe some other association or, anything that might be involved when it comes to dealing in certain rental agreement positions.
How about a resident who's an officer of GSMOL? Would that be a conflict of interest?
That's a good question. I'd have to think about that one.
Yeah.
The question is that, I don't know the process for being a representative for GSMOL. So if this is, again, you get together and as residents of a park, you determine that this individual is going to be your representative, then what criteria does that have to meet in order for them to be that position?
And maybe we shouldn't be too concerned about those issues, frankly. I mean, all we really want to make sure is that the person who's speaking on behalf of the residents of a particular park has the authority to do that. And so in the settlement realm, we want to make sure that that representative is submitting a settlement proposal that at least a majority, hopefully, of the park residents support.
Well, the other question I might have is, suppose that we want to keep it completely clean from the city. Maybe this would not be a representative on any of our commissions, within the city of Sonoma. And that, I think, is probably a little bit more pertinent to where I'm going, in the respect that there be true non-conflict in any way associated with the city. But, again, I'm just throwing this out.
Yeah, no, this is good brainstorming. That's what we're doing
Let's
here.
keep going with Hunley. Hunley? Oh, Agramonte.
Thank you. I feel like I'm on a football field. Agramonte.
Councilmember Agramonte.
Yeah.
I guess, Jeff, I'm confused, I guess, with respect to number 5, the representative. Is that representative the person that goes to OAH possibly because they're called forward? Or this is just the general negotiations and they're given that authority to make these decisions for the residents? I need clarification, I'm sorry.
I don't think that the ordinance spells out what this representative's powers would be other than, as my memory serves me, other than participating in the settlement process.
The idea is there, it's just an idea for that.
Yes, it would facilitate the settlement process, whether that person would go on and testify at the state hearing, in my view, and whether that person has the requisite level of knowledge about the items that are coming before that hearing officer.
So here's where my concern is being involved with labor negotiations. I don't know if anyone should be given that authority unless whatever information they get from negotiations, they bring back to the residents, and the residents make a decision and give that to the representative, and that would be the way to act on that. I just don't know. I don't know how anyone else feels. I just don't know if that person should have the authority to do that, unless, of course, it's the issue is they're very, people trust that authority.
I think most of the parks have HOA boards, and maybe the one way of handling this would be to make sure that in order to understand the scope of the representative's authority, we could require HOA boards to submit a writing to both the park owner and the city as to the nature of the representative's powers. That might go toward getting a better read on that.
Thank you.
Councilmember Edwards.
So, having met several members of the mobile home parks, I think that we need to rely on them to, I think the people that they want to have represent them are going to rise to the occasion, and I think it's only fair to the owners and to the city manager to have one point of contact to deal with rather than many. And as far as commissions, I don't really see an issue with conflict of interest. I mean, if there were somebody sitting on this panel, I would say there'd be a conflict of interest, but I don't really see anything coming towards planning commissioners and otherwise that would create a conflict, and I'm not too concerned about conflicts, but I like the idea of having one person to deal with, and I think the residents of the park are very well capable of identifying their leadership.
Councilmember Agramonte.
And that was not my intention with bringing that up. I know that they're capable. I've met a lot of people that, have really been very open in explaining information, and that's not the point. It wouldn't be a lot of people testifying or representing. It would be that one person, but whatever is decided at a negotiation table, for that one person to bring it back to the residents, and that one person goes back with the decision that was made. I just think it seems to be I just seems to be more fair.
Hun-
That's all I was looking for.
Hunley?
I agree that generally, I think whatever internal mechanisms the parks want to do to pick their person, I don't think that we should get too entangled into it. But I just want to make sure that it's like a designated, like verified person, so everyone agrees that who that is. But I also want to think about some sort of contingency plan in case there is some sort of internal rift, and then they can't decide who the person is, and suddenly we can't proceed with our process because I don't want things to get hung up. So I just want there to be like some sort of contingency plan. But generally, as long as, they have their process, they pick their person, that's fine, and they'll, be a part of this system as we've intended them to do.
Edwards?
So would you say something like that's identified to the city manager or to the council each year, say in January, that we know who that person is in each park and it's identified formally to the council would work for me?
Yeah, I think identified, and then, for additional verification, there could be some sort of like period of for people to contest it in case there's 75% of the park is like, no, that's not who we picked, and they can come and do it.
Gallion?
Just, for me, it's again, another clarification. A lot of times, individuals will be coming and speaking before the council on public comment. If this person is the individual that you are selecting there, then they are the voice of the particular organization, or they don't speak in that particular capacity. So I think it's just a framework where someone just has to identify what the tenets are of this particular position, and that's the authority that they are vesting in that individual. Because if this individual came and was not speaking on behalf of the organization in a public setting, who are we to know, what they've been authorized to say or not say on their own time? So I just want to be very clear about what this person actually is entrusted with.
Councilmember Agramonte?
I'm comfortable with that. I think that Vice Mayor said that very well. The other side of it is that when a representative is chosen, that the residents possibly understand clearly that this person is representing them, and that I don't know whether it's possible not to go back to the residents and say, here's what the offer is on the table. I just basically think we need more clarification. Thank you.
Vice Mayor Gallion?
So I feel comfortable with a little bit more definition of what this representative actually is. We've had some wonderful champions who have come to council and speak on behalf of the parks themselves. So I don't think there's a lack of confidence in who this representative would be. I just think it would be important for us to know when this person identifies themselves what they are actually in charge of. So I am in support of this with clarification.
And I'm also in support with the way it's written. I would believe that it would be up to each park residents to do their election and keep the city not involved in that. And I believe that's what Edwards and Hunley, on the straw poll with Gallion and Agramonte, looking for a little bit more information on their election and recall process, along with conflict of interest. Which leads us to 5A.
I think we've been covering 5A as we've been discussing about 5, so I've got a good sense of what the council wants on that.
Okay. 6.
6, the city's current rent control ordinance has what's called a partial vacancy control mechanism. That is, when a park resident voluntarily sells his or her mobile home to another person, or voluntarily leaves the park, takes the mobile home with him or her, or is properly and lawfully evicted, the park owner is entitled to increase the new resident's rent by up to 10%. There are some exceptions, meaning that no increase can occur upon a transfer to certain relatives, a spouse, brother-in-law, father, there's a list of them. The residents are proposing that 10% bump up be halved, reduced to 5%. The park owner is proposing to do away with vacancy control altogether so that the new resident would pay market rents, but that if the council is of a mind to continue some form of vacancy control, the park owners are recommending that the only exclusion from being able to increase rents to some degree would apply to a transfer to a spouse, but not to other relatives. Those are the proposals before you. The legal framework is as follows. Vacancy control has been upheld by the courts. In the recent case involving the city of San Rafael, its ordinance prohibits any increase in rent upon the vacancy of a space. And that ordinance was upheld against a constitutional challenge. Various charts have been submitted to the council by the residents as well as the park owners showing the various cities and counties throughout California that have addressed vacancy control. Some in the county of Sonoma, some cities that have rent control do not permit any increase. Some do not have vacancy control. They allow rates to float to market upon the transfer of the mobile home or the vacancy of the space. So it's a total policy question in my view, and up to the council.
Is there any colleague on the council who would like to begin? Vice Mayor Gallion?
Defensively, in a position, given the information that we have before us to make this, if this was brought to a lawsuit, we would have grounds, yes or no, in which we would be able to defend our position in this ordinance.
That's a very broad question. It so much depends on the basis for the challenge. The courts typically look at the effect of the entire ordinance, not just one piece. So looking just at the vacancy control provision alone, in my view, if that's the sole target of the challenge, that challenge would be unsuccessful. Because there are other ways under our ordinance to assure the property owner a fair return, specifically the procedures that we've just spent an hour talking about. That the property owner, if he or she or it believes that it's not getting a fair return on its investment or its property, it has the right to petition for an increase in rent to assure that.
And I think that actually speaks to a lot of our languages around Section A in some of our clauses we've just done about a fair market return. You know, the processes around that. So I am in support of this.
Hunley?
You had made a comment about this in the memo that you sent us earlier. Can I ask about that, or should I ask you about that in closed session?
Closed session would be the best place to talk about that memo. It was said in confidence.
This vacancy control is something that I definitely support. So as far as what the actual amount is, I think I have some more questions about it, but generally this is something that I would like to keep and also discuss the possibility of perhaps tightening it up a little bit.
Edwards?
I would be considering, when I look at the inventory we have of affordable housing and so on in Sonoma, I'm going to probably be leaning more towards the 5% rate and figure out in closed session what our strategy is on that.
Councilmember Agramante?
I agree with Councilmember Edwards with respect to the 5%, and just taking a look at that figure, and with respect to the vacancy. Agree with Councilmember Edwards.
Edwards?
Just want to add one thing to that. If it's determined that it's based on the settlements we're looking for across the board, if the owners come back and can argue that that needs to be 7.5% or 6% or some other number, I'm going to be open to that as well.
And Vice Mayor Gallion?
I believe I said that I was in support, but not into, or a certain percentage. And I believe that it should be 5%. I don't believe it should be less than 5%. I believe it should be 5%.
And I also would agree that I'm in support of number 6. I like the 5%. For public, we have a consensus of yes with a little bit more talk, which we'll move to number 7.
Number 7, I think is going to be probably something that is more thoroughly vetted once the draft ordinance comes back to the council. Right now, the draft ordinance has 2 or 3 pages of incomes and expenses that are proper and some are not proper. The parks representatives have said that greater clarity needs to be injected into that listing. The park owners haven't really given us much help in identifying the areas that need to be clarified, but I think that that's sort of the devil's in the details that you would better address later on when the ordinance comes back for us to take a look at and go through it page by page.
Thank you. So we'll move to number 8.
This particular requirement is included in the proposed ordinance that lays out what a complete rent increase petition looks like and what needs to be included. The park owner's representative has argued fairly consistently for the last 3 or 4 or 5 years that sort of every layer of obligation that must be honored by and adhered to by the park owner in making an application and processing a rent increase petition chills his or its or hers right to pursue a rent increase. Certainly the requirements cannot be unreasonable, but I think requiring that a petition be complete and contain the requisite information for the city to determine whether the petition should be approved or not seems to me to be fairly reasonable and fairly fundamental. So I don't have at all any problem with requiring a complete application and specifying reasonable conditions to what constitutes a complete application.
Vice Mayor Gallion?
I'm in support of that only because of what we're being asked to change is our internal process. And if you were going to go ahead and have experts look at this, you want to actually be analyzing what is before you in its its totality, rather than to go ahead and have certain things pop in at a time. So I think it definitely needs a definition of a complete application also added to this. What is the requirement?
Councilmember Edwards?
So I support having a complete application. I travel quite a bit out of the country, and if you don't have a complete visa application, you end up living somewhere else. So I'm happy to have all paperwork complete.
I support this as well.
And I support this as well.
And I also do support this. So for public, that was a 5-0 for number 8. Any more questions? Seeing none, we'll go to number 9.
9 and 10 are the same. We've talked about this before. I think there was some unclarity in the language of the ordinance that led to a dispute amongst the attorneys representing the residents and the park owners over whether or not legal fees and other costs in processing a rent petition could be recouped to the park owner if the petition is successful over a 5-year period with interest. And in comments most recently made by Mr. Constantine in the last day or two, it seems pretty clear to me that the intent was to assure that those fees in a successful petition be passed on to the residents to reimburse the park owner, as long as they're spread over a 5-year period with interest. And that's the gist of number 9 and 10.
Edwards?
So to me, this is a real incentive to stay out of, no offense to the lawyers in the room, but to stay out of the altercations, and I think this will create an opportunity for quicker settlements.
Hunley, or Vice Mayor Gallion, question?
And I just wanted to also stipulate that we would go ahead and define what the interest was or what it's tied to.
Hunley?
I support both of these.
Councilmember Agramonte?
I support this as well.
And I also do support item number 9 and 10. Number 11?
Number 11, the residents are proposing that if the process that results from a park owner seeking a rent increase is delayed beyond 120 days, so if the ultimate decision takes more than 4 months, is that right? Yeah. To occur, I have in the parenthetical 180 days question mark, because actually there's another provision that talks about it being 180 days, but I think the purpose, I think that the thrust is 120 days. If it's later than 120 days, then the city is required to grant a retroactive rent increase covering the delay period. City, by that I mean either the city manager or, if on appeal, the hearing officer from Sacramento. This is what is being proposed by the residents. I think it's reasonable. There are cases that talk about unreasonable delay and reaching rent increase petitions, giving the right of the park owner to seek additional rent increases to pay for the rents it would have received during that delay period. And again, this is based on a successful petition, meaning if the park owner is denied its request, then there would not be any rents that would be owed during that delay period. But if a park owner in good faith prosecutes an application that takes the city manager and the hearing officer 15 months to decide and grants the rent increase, the courts are clear that during that 15-month period, the landlord should have received those rents. Again, this is only triggered if the delay is more than 120 days. So a 120-day delay would not trigger the need to pay the park owner additional rents.
Vice Mayor Gallion?
I agree. You know, knowing that you have a bill coming in that could go ahead and it keeps getting larger every month because of something that could be successful or not is harrowing, especially in a situation where we're trying to go ahead and affect some individuals who are living on fixed income, whether that be, you know, at any age level. And for me, I think it's appropriate to know the 120-day limit. I think is reasonable. I'm not quite sure about how I feel about the 6-month limit, so I'd like to know a little bit more about why it would be 6 months, why there's 2 of them, 120 or 1.
I think it might have been a typographical error,
Okay.
and that's what I'm attributing it to.
Well, I would go with 120, and then I could be in support of this.
I agree and go with what Vice Mayor Gallion has offered.
Councilmember Edwards?
I'm in support, and I think what I hear you saying is that 120 days is reasonable, but if it goes to 180 days, then the amortization issue kicks in.
Actually, if it goes to 121 days, amortization kicks in.
Gotcha. So I'm in support.
So as far as appeals go, I mean, will there be cases where a decision could be made, appealed, all within 3 months? Because if it's even if
4 months.
or 4 months,
Yeah,
or even
4 months.
within 4 months. This just seems to say that if it's ever appealed, then it's always going to end up, if it's overturned, it's always going to go back to the residents, because that seems really short for the whole
Let me do
process.
some investigation. I'll call the State Office of Administrative Hearings and see what the typical delay and timeline is between a request for a hearing with that office and when a decision is made. I can find that out, and I'll report back to you on that.
Okay.
I'm assuming that it is, that this process can, under normal circumstances, with all parties acting in good faith, can be concluded within 120 days.
Okay, I also agree, and we'll bring that back, number 11. Let's move to number 12.
Excuse me, I'm writing some notes to myself. Number 12. This is a proposal by the residents to authorize residents to petition for rent reductions where the park has reduced services or amenities.
Is there any colleagues on the council that have questions? Vice Mayor Gallion?
When I was reading this, I, for the life of me, okay, I really wanted to see some examples of what reduced services were. It's hard for me to imagine this in the abstract. And I understand not having a swimming pool or something of that nature, you know, in that respect, but I think I would be looking for something a little bit more concrete as to what qualifies as reduced services.
Most cities that have rent control ordinances that pertain to mobile home parks do have a reduction for reduced services and amenities. I know Santa Monica and Runner Park have adopted extensive regulations governing this issue, and I would be proposing that the city of Sonoma do the same, so that when those come back to you, you'll see the potential list of reduced services. Also, I think it would be helpful for me to consult with the park owners and the park residents to find out what other nature of services exist there that might be reduced, so that we could add those to the illustrative list in the regulations.
Thank you. I just think it would be more clarifying for me and probably less cloudy.
I think it's a good idea. Thank you, Jeff, for checking that, because I'm sure there are vendors that they contract with vendors, garbage, all other services. So I just don't. It's a little unclear.
Edwards?
So this one's pretty obvious to me. My grandfather ran a mobile home park in Fullerton, California in the 70s, and they did nothing but try to provide more services. He didn't own it, but he managed it. And I can see where definitely the residents would need to have a rent reduction if services were denied, whether it be hours in buildings or use of buildings, swimming pools, etc. So I'm going to support number 12.
Hunley?
I generally support this, but I would want to see the guidelines, and I would want really specific guidelines so that Carol doesn't end up getting lots of lists every year about things that are happening that don't quite qualify.
And I also agree with that I would be supporting it, but I would like to see a list of what services would be added into that. Is there any other questions on 12, and did we give clarification on the straw vote? With that, we'll go to number 13. After you finish your notes.
Thank you. Number 13 is a proposal by the residents to impose upon themselves a supplemental administrative fee. And the fee would be chargeable to the residents, but it would be collected by the park owners. If the residents do not pay the fee, the city could not pursue the park owner for collection, but would have to pursue the individual resident. And the park residents are proposing this in order to assist in initial defraying some of the additional costs they foresee the city incurring, particularly with the city manager taking on the first stage of review. And so this is to assist defraying those costs.
Councilmember Edwards?
So Jeff, currently we collect $24 a year through the owners now, so this wouldn't really change.
It would not affect that. I think the proposal is to increase it by, which, it's actually in the ordinance.
So the process is already in place.
Oh yes, the process is already in place to collect. The $24 current charge, however, is payable by the park owner.
Gotcha.
This would be payable by the residents.
Okay.
Hunley?
So the difference between the two, besides who, is it ultimately who's responsible? Whereas if it's not paid at the $24 and the city gets it from the park owner, but why is this different that the city would have to go to the individual person and not the park owner?
There's a concern of imposing upon the park owner a sort of a collection effort, that it shouldn't be required to actually not a collection effort, because the park owner will likely be collecting it and paying it over to the city. But the residents didn't think it was appropriate for the park to be liable for paying for administering a program that it's already paying for.
So I see what this, I think the sentiment behind this, I think, is it's really nice, but as far as paying for something like this, it's not something that necessarily is even supposed to be borne by the residents themselves. I see this is something that the city pays for as a whole, because it's something that we find valuable and it's a part of our policy. So I don't find this to be necessary.
Vice Mayor Gallion?
So the question would be, I'd like to see, the beginning and ending of this fee. So, in other words, this fee is gone ahead and it's collected when? And what is its purpose? How does it get drawn down? How do we account for how we've spent it? Or does this ultimately end up going back as a reduction of fees that would come, or any adjustments that would come as of any action? Because that's a lot of paperwork to keep track of.
Well, I don't know that.
And I would just like to say, it's like, let's kind of track what the cost of collecting something would be for the city in order to be able to report back. Because to me, if it's a break even, it's a nice possibility, but it's also encumbering. And I don't know that it actually shows that there's any benefit to the resident themselves, other than knowing that whatever fees they would be responsible for would be amortized over 5 years. And they would actually be paying that end of it.
Well, those fees that are amortized over 5 years would only be paid if there's a petition to increase rents. And we have not experienced a significant number of those petitions in the last 10 years.
I really would like to see the life of what this particular fee would be and the cost for accounting for it throughout the process, before I could say I could support that.
So Jeff, this is existing policy, is that what you're saying?
No, this is
No?
new. This is new.
Okay.
This would be a new, they call it a supplemental administrative fee. It's described in page 26 of the ordinance.
I just feel it's much ado about nothing. I mean, I don't know how we figure into this, but
Well, maybe one approach would be, since we are currently collecting around $10,000 a year from the park owners to administer this program, I think it would be somewhat easier for Carol in particular, or her successor, to keep track of how much time she or her successor spend in administering the program, now that the city manager is going to be taking on a new and increased role. And then at the end of each year, maybe during the budget cycle, come back to the council and say, well, I spent 4,000 hours last year working on rent control. $10,000 did not pay for that 4,000 hours, so we need to think about how we pay for that. This supplemental administration fee went beyond just reimbursing the city for its costs of administering the program. If you look at all the ways it could be spent, it included paying for lawyers to defend the ordinance against challenges presumably brought by park owners. So it was much more expansive use of the money. The administration fee that is currently charged at $24 per governed resident is to be used for administering the program. It probably not to be used to defend the ordinance against challenges by the park owners.
Hunley?
Yeah, related to that, I think that once we pass an ordinance, we are passing it because it's something the city supports, so it'll be defended just the way all of our other ordinances are. So just because I see this as a part of public policy, and, I mean, how would this differ from it instead being some sort of like separate tax, like a mobile home resident tax that would be more straightforward? I mean, it seems like it's the same end result if you're going to have like a small additional tax, but this is a fee, so what's the difference?
Well, this is being proposed by the residents. They are prepared to pay the city some additional money to make sure that the costs the city incurs in dealing with this new concept are defrayed, are paid for. So it was an incentive, I think, to convince the council that this would be a no-cost proposal to the city.
And I appreciate that, but I think that the city should decide if it's something we're going to invest more into spending Carol's time, staff's time, whatever. It needs to be something that the city just wants to incorporate the cost into our annual budget.
Edwards?
So I'm actually all for imposing this administrative fee. I think the residents proposed it, and I think we're going to find costs that are going to creep into this down the road. So I'm all for number 13.
Vice Mayor Gallion?
I'm for going ahead and leaving this open. And by that, there could be language that would say, if not at this time, that we would impose this, that at a future time with X amount of notice, we would go ahead and have the right to do this. And I think we should have a cause behind why we would do this rather than just asking. This is about, going ahead and protecting our housing stock that's here, and especially our affordable housing stock, and some people could actually be using that money if we're not likely to use it ourselves until we get a handle on what we need it for.
Agramonte?
I'm in support of this, but I'd really like to know the cost, and I think there was an idea that was shared possibly that the city manager would provide some figures at the amount of time that's spent on this.
I am in favor of number 13. For public, I think the straw poll was over a 3-2, with 2 council members having some more clarification on the cost.
No, I don't support it.
We'll move to number 14.
And number 14 is an add-on. The current process that applies to a rent increase based upon a capital improvement provides that with the application is submitted, and the city clerk now sends a notice of the rent increase application for a capital improvement to the residents. The residents then have 15 days to protest, and a majority plus one, or a majority, 50% plus one of the residents who are the beneficiaries of rent control, whose spaces are governed by rent control, can protest. And if that number within 15 days do protest, then the matter goes to hearing. Even though the council has indicated they're interested in the new 2-stage process, the first stage being the city manager, the second stage being the state hearing office, I still think that this is another way to resolve at an early stage rent increase requests. And so I would recommend we keep it for capital improvements, meaning that once the petition is submitted, the residents would get notice. If less than a majority protested, then the rent increase goes forward, and there's no need for a proceeding with the city manager nor with the state hearing office. On the other hand, if the requisite numbers of residents protest, then the normal process would move forward with the city manager resolving it at the first stage. The residents have complained that 15 days is a very short period of time to gather the necessary signatures to protest and to also understand as best they can the nature of the petition itself, because it does require the residents' leadership to read the petition, see the documents, see the estimates, the construction estimates, et cetera, and come to a conclusion as to whether it's justified. And that takes some time. And it may, in fact, require the residents to retain their own experts to review the request. So they're recommending that that protest period move from 15 to 30 days. I would recommend that. I think that's a fair request.
Vice Mayor Gallion.
I'm in support of that because 15 days doesn't necessarily mean they're 15 business days. And if you wanted to go and have your own professional actually advise a group, you may or may not have the ability to actually have them appear before a group or call a group together within just a 15-day period. So I think 30 goes ahead and is reasonable and has the appropriate amount of business days in it that could affect what you're trying to achieve.
Councilmember Hunley.
So as far as the timeline goes, so they file a petition, this would give them 30 days to protest, and then I assume there will be, like, the hypothetical timeline for Carol to make her decision is like another 30 days? I'm wondering, because we talked about the 120-day limit before,
Yep.
so that's already
Yeah.
the first month,
Yep.
and then say she takes a month, and that gives 2 months at the end. So I think that if we do this 30 days, I wanted to know more about the hearing anyway, but I
Yeah.
think that it should realistically be able to get through the process within whatever our deadline is.
I agree, and at the same time, though, that 120-day envelope incentivizes the park residents to move quickly and probably faster than 30 days. Because if that 30-day wait period pushes into that 120-day ceiling, they're going to end up paying for, well, in this particular instance, it's probably not that important, and maybe we need to think about that, because our current ordinance reads that the rent increase does not go into effect until the improvement is completed.
Oh.
So that 120-day period may not be applicable to this type of a petition, and we need to give I'll give further thought to that, because it may not be an appropriate window for capital improvement pass-through petitions. So it's a good issue that you spotted.
And I do support 30 days.
So I support 30 days as well, and I think it'll create an opportunity for the owners to bring very good projects to the group, and then it'll give the residents a chance to respond and an incentive for both. So 30 days for me.
And I'm comfortable with this as well, and go for the 30 days.
I also am in support of item 14. With that, we will move to back to number 1 on the matrix.
I was wondering if the council would like a short break. We've been at this for an hour and a half. Do you want to have a short
With
break
that,
and
the
then come back?
council will take a 5-minute break. 5 minutes.
Thank you.
Gee, you're on the hot seat today. Okay, coming out, shoot. No worries.
Yeah, you guys are doing very well, and you're making reasonable comments.
Yes.
That's always good.
I was up there studying last night.
Oh, I know.
It was like Q&A.
Oh, I know. God,
I'm sorry, I didn't mean to find it.
that's quite all right.
I just figured we can't know everything. It's
No.
very research.
Yeah.
Thank you. Sure. Appreciate your decisiveness as you're going.
Oh, good. Good. Thank you.
You're, it's very.
I'll be back at 5. It's a 6 o'clock experience, isn't it?
Yeah.
That's gonna really blow everything we had planned for tonight. Better tell our next running off.
we're going to go ahead and call this meeting back to order in about 2 minutes.
I'm just going to write this right here. No way, Jose. I bet. We bet if beer to come out. No, dog, you get it. There wasn't overwhelming.
Are you guys? Okay, we're going to go ahead and call this meeting back to order. So we will bring it back to the city attorney. And right now, we are on park owners' proposed amendments on the matrix, number 1.
Yes, thank you, Mr. Mayor. The park owners have made certain proposals also, and we will now begin with those. One of their proposals is to increase the annual automatic. Hello?
I think it's on.
It was. I'll get closer. The first proposal on this list, and these are in no particular order, by the way, is to increase the automatic rent increase, the annual automatic rent increase from 80% to 100% of the CPI, and eliminate the 5% cap. Currently, as we mentioned before, the annual increase is 80% of the CPI, but under no circumstances may it exceed 5% in a given year. So there's a 5% cap. So the park owners are suggesting that we do away with the cap and we grant the park owners 100% of the CPI. Again, this is a policy question. The Supreme Court of California has ruled that no annual increase, automatic increase, is required to meet constitutional muster, provided there's that escape valve. The escape valve being a reasonably prompt process allowing the park owner to seek individual rent increases to assure that the park owner's earning a fair return.
Does any colleagues on the council have a question? Vice Mayor Gallion.
So I think we've seen this before, but just refresh my memory. CPI, how volatile has that been?
Not very volatile at all for the last 15 years. It's been relatively nominal. Almost historic, I think.
Thank you.
Is anyone prepared to do the straw? Councilmember Edwards.
So I think that volatility is going to change at some point in the next few years, and I'm going to vote no on this one. I'd like to see it stay at the 80 and with a 5% cap.
Councilmember Hunley.
I agree.
Vice Mayor Gallion.
I had read some of the information concerning the fair market value at 75%. So I feel that having 80 is more than adequate at this point, so I will be supporting the fact that we stay at 80%.
I'm comfortable at 80%.
I am also comfortable at 80% and would like to keep it that way. And for public, there was a 5-0 to keep it at 80%. Vice Mayor Gallion.
Did we also incorporate that we would not be eliminating the 5% gap?
Yes.
Yeah, I took the vote to include leaving it as is, everything as is.
Thank you.
Item 2.
As I mentioned before, the park owners are proposing the elimination of vacancy control, thus permitting park owners to charge market rents to new owners of in-place mobile homes.
Councilmember Edwards?
I'm going to vote no on this one as well. Based on the previous discussion and our desperate need for affordability in Sonoma, that's my vote.
No.
Vice Mayor Gallion?
I am voting no on this. I believe that what we're trying to protect is exactly why we need to have vacancy control.
I am no as well.
And I also am a strong no on this, so there would be a 5-0 straw, for no. Item 3.
Item 3, the park owners are recommending the following thing. The city's rent control ordinance, the fair return portion of it, is based upon what's called the maintenance of net operating income. Meaning that if the net operating income in 1992 was set by market forces, and presumptively it was because that was the last year that park owners in the city of Sonoma were allowed to select rents at any level they wished, then our ordinance basically says that as long as the net operating income in 1992 adjusted for inflation remains the same or better, then there's no need to increase rents other than the annual adjustment. So for example, if in 1992 a park owner's net operating income was $100 and adjusted for CPI 10 years later, it would be $200. If that park owner is making $200 in net operating income 10 years later, then that park owner would not be allowed to apply for a fair return increase in its rent because it's already earning the same net operating income it earned in 1992 adjusted by inflation. The inflation that is allowed under this formula in our existing ordinance is 80% of the CPI, not 100%. The park residents have proposed that it be bumped up to 100%. And that is the same recommendation that the park owners are recommending. I think there was some confusion initially in the initial drafts of this proposed ordinance on the part of the park owners and probably myself too as to whether that was the case. But it's been clarified in the intervening time that we've been having these dialogues and debates. So the park residents and the park owners are in agreement on this issue, that the inflator factor under the maintenance of net operating income should be 100% of the CPI.
Vice Mayor Gallion?
Now, I do remember you saying that we still have to define the MNOI components, correct?
Yes, we have to better define what are the acceptable expenses and what kind of income those expenses would offset to produce the net operating income. But that is just, that exercise would be important to determine in a given year whether what was the net operating income.
So I personally feel I want to defer on this particular issue until that is arrived at and both parties agree to that, because that is a tenet that is actually being incorporated, as I understand it from what you said, in this particular paragraph.
It's an important component, but in terms of what you look at to determine whether the park owner is receiving a fair return over time, it's not critical, because once you've determined what is an appropriate formula to determine a given year's net operating income, then you look to see whether or not over time the park owner, through the annual automatic adjustments, is keeping pace with inflation.
Well, thank you for that clarification. With that, I can go ahead and support this.
And I support this as well.
And I support this too.
Yes.
And I also will be supporting this, yes. So for public, we have a 5-0 on a straw poll vote. Item 4.
Item 4, the council in 1998 adopted a resolution basically creating some regulations, if you will, to further implement and define and refine what the rent control ordinance meant in a number of places. And one of the things that resolution did was it actually identified the amortization period for specific capital improvements. So for example, The resolution identifies that the appropriate amortization period for a new sewer system or an upgraded sewer system is 50 years. It did the same with a water system, a water distribution system. We remember Rancho de Sonoma just went through a major water upgrade. And had we not entered into a settlement agreement with Rancho de Sonoma, it would have likely have come to the city asking for a rent increase based upon the costs it incurred in upgrading its water system. Now, it did incur a lot of costs, at least for the initial improvement, because they were able to get a state grant that paid for, I think, most, if not all of that. But to the extent they did not obtain a state grant covering their costs of upgrading their water improvement, they would have come into the city, go to the rental review board and ask for an increase in rent to pay for those capital improvement costs plus interest over the requisite amortization period. And at that time, and to today also, that would have been 50 years. So they would have had to divide those costs by 50 years, and then again by the number of residents who are obligated to pay those that cost, and that would give you your per year, per resident additional rent increase plus interest. But the rent increase would have lasted for 50 years, and at the end of 50 years, that rent increase would have then been terminated. The park owners are asking that 50-year period for these two types of improvements be reduced to 15 years for sewers and 25 years for water distribution systems. The park residents' attorney argues that it's rare that water systems and sewer systems are repaired or replaced every 15 or 25 years. So that there's an argument, they make that argument that these systems are in place for many, many years, and certainly 50 years to them seem more reasonable.
Vice Mayor Gallion.
We had written in the first part of our matrix table that we would be introducing probably some research on what would be the life of, or an amortization period, more standardizing that we could use as a table for that. Is that something that we could put in place here as well under this tenet?
Yes, I think it would be a good idea, frankly, along with adopting and preparing a new ordinance, that we create a comprehensive set of regulations. And in that set, we would more clearly and in greater detail lay out the various amortization periods that would be applicable to various capital improvements. And I think that's the place to address this issue, to be honest with you.
And it would be impartial, right? Because this would be taken from an independent source, not...
There are various amortization schedules that the IRS has developed, I wish it was very easy just to go to one table. It's not, unfortunately. And frankly, even if you go to some of these established tables for tax purposes, they don't always reflect the real useful life of the improvements that they address. A sewer system, if it's done properly, will last you for 30, 40, 50 years. It really will. And we've all experienced that, and the city has too. Likewise, a water distribution system, you're not replacing those every 15 to 20 years. But that's a discussion we can have later on when we're addressing the regulations.
Okay, well, my intent would be that would be part of the discussion in order to be able to go ahead and support this, that there would be language supporting a standardized schedule for these type of capital improvements. And then I can say yes.
And that's exactly how I feel. As a city, we must have these numbers of the length of time for services, for these type of services. And I will be willing to make that a yes as well.
Edwards.
I would as well as to figure out some middle ground between that 15 and 50 years and between the 25.
I support a comprehensive discussion of all of the different capital improvements and nailing down what we think the amortization period should be for each of them.
And I agree with Councilmember Hunley also. And we have a 5-0 on that, so we'll move to number 5.
I think the same discussion applies to number 5. Again, this would be deferred until we came back with those sort of standardized approaches that you've all been mentioning.
Thank you. Number 6.
Number 6 addresses the procedure we earlier discussed regarding capital improvement pass-throughs. Here, the park owner is suggesting that the ordinance be amended to eliminate the right to protest rent increases for necessary capital improvements. I think that that's not a good idea. I think this is a mechanism, frankly, to allow the park owners to obtain rent increase approvals more quickly than not. Now, maybe in reality, it rarely happens that its petitions are allowed to go forward without a majority protest. And maybe that's the reality that the park owner sees in the process, and thus why have this sort of unnecessary protest step, because it always is taken. So let's just expedite the process. Let's go to the city manager, forget the protest. And there may be some value in that discussion, and we'll hear probably later about that from the park owner's representative when they speak. But that's the genesis, I believe, of that particular proposal.
Edwards?
I'm going to vote no on that one.
No.
No?
So here's where I'm a little stuck, because we've already determined that we're going to look at number 5 to understand what the definition of capital improvements, and then with 6, if we've already determined what that is, I would imagine it's the amount of the increase, not necessarily an increase. If it's already been determined that that's an approved approved under this meaning of capital improvement,
One of the things that's important to remember, and I've not talked about it, is that the ordinance as currently drafted, and likely will retain at least this concept, not every capital improvement, the cost of which can be passed through the residents. It must be a necessary capital improvement.
I think that's...
And that's an additional layer that we need to talk about, because some capital improvements are done because of woefully bad maintenance and repair. It's deferred maintenance, goes on and on and on. Finally, the only thing that's left to be done is to replace the entire capital improvement. Is that something that the residents should be paying for? Because that allows then the poorly managed park to avoid its normal maintenance obligations, paying those costs out of its own pocket, because maintenance and repair is not recoverable through a capital pass-through. It might be recoverable through a general maintenance of net operating income petition, but not through a capital pass-through petition. So this, as we've discussed before, if a park owner comes forward with a capital improvement cost pass-through petition, our current ordinance, and thus far the council seems inclined to retain that in the new ordinance, allows the park residents to protest if they want. But they have to muster a majority of the residents to protest it. If they don't, then that petition slides through and is approved. If they protest with sufficient numbers, then it's not allowed to slide through, and it must go to the city manager under the new ordinance. So the proposal here is to eliminate the protest process altogether. There's no more protesting. That would go right to the city manager. Every capital pass-through petition goes right to the city manager, and the residents do not have the power to protest it, because in the past they've protested them all. I'm assuming that's sort of what the thinking here is on the part of the park owner in making this proposal. We can certainly hear from them later about that. That's the genesis and the nub of this particular issue.
So I offer a no on this.
And I also would say no on this. I don't like the language. So with that, we have a 5-0. 7?
As I mentioned before, our current resolution 57-1998 identifies certain transfers of mobile homes to certain relatives that do not trigger any increase in rent, even though it's theoretically the mobile home has actually been conveyed in placed sale. It's like an inheritance, for example. A surviving spouse finally is living in the mobile home and finally dies, and his or her will bequeaths the mobile home to his son. Our current resolution says that does not trigger any increase, the right to increase any rents whatsoever, not even the 10%. And the park owners are recommending that type of exemption be only applicable to a transfer to a spouse and not to other relatives.
Councilmember Edwards.
I'm going to vote no on this one as well. Just thinking, I think it should be for any family member, and if there's a medical emergency or death, what have you, there may be financial issues for the surviving family, and this, I wouldn't want to see any increases on it.
Councilmember Hunley.
I also vote no.
Vice Mayor Gallion.
And I vote no.
And I'm a strong no on that also. So we have a 4. Oh, pass. Okay, sorry. I thought you were passing on the question. Vice Mayor Gallion.
All right, so I think my only reservation in this is that I think that there's some standardization here where they're trying to enact like a house in the respect that you can pass on to your spouse the house, but after that, that any other living resident or any other living family member then becomes, engaged in a different process. I still don't think I can support this, but I do understand that there's some logic behind this. So for me, I just want to say that it's, I will go no, because I don't think that I could support anything except this right now.
Okay, for public, our straw vote was 5-0 on no on number 7, which leads us to number 8.
This proposal seeks to add a section to the ordinance that would allow park owners to pass through to homeowners any fees or charges that a majority of the homeowners request or agree should be passed through.
Is there an example? I'm sorry.
I would ask that you ask the Parks representative to speak to this issue when it comes time for that person to be speaking to you. I'm not quite sure why this is being proposed and what kind of fees and charges this would typically encompass.
So are you saying that we should pass on this?
I think so.
Okay. Do I have council support to go pass on this? And we'll,
Yes.
okay. For public, we are passing on issue number 8 and moving to issue number 9.
Number 9 goes to the issue we've discussed before, and that is any fees incurred by the park owner in having to pay for the city's own experts. The park owner is recommending that those expert fees be, if it's successful in its petition, be passed on to the park's residents immediately, rather than amortized over 5 years plus interest.
Vice Mayor Gallion.
That's a no for me.
Councilmember Edwards.
That's a no for me.
No.
No.
And I'm also a no on that, which completes our matrix. Does any city council members have any questions before we move on through the process? Councilmember Hunley?
Well, I know we had this last question for the park reps, and I just wanted to add to that, to hear from them about the selection of the park representative and sort of the anticipated process for that, and also perhaps if they could address my concern of having some sort of contingency plan unless there's, in case there's some sort of, rift inside and we need to figure out who it is.
Okay, at this time, I would like to open up public comment. We're going to allow 10 minutes for each side on the attorneys. And which would like to go first? Yes, if you want to come to the microphone, please.
I don't want to do that yet. It's a point of order. Point of order is that we have 3 parks, but
You have to come to the microphone, or we'll have the microphone brought to you.
we three parks, okay, not represented by the same people. So we would ask for an extra 5 minutes.
So you were asking for 15 minutes
Correct.
instead of the 10 minutes. We can allow that, that's not an issue. But the other side will have 15 minutes also. With that, could I have the other attorney for the homeowners present? And would you like to go first?
It doesn't matter. But I would like some time in rebuttal then.
We're going to allow 15 minutes. If you want to use 7 minutes and come back for rebuttal. This happened last time, there's only 15 minutes.
Yeah. And I'd like to thank the city council for your careful consideration of everything today. I'm not going to argue any of the law on this because I think that's been really...
Can we have quiet in the...
I'm sorry? Oh. Could you hear me now?
Can everybody here start talking and we'll...
Hello?
If you can't hear during any time, just go ahead and raise your hand and I will acknowledge them to speak.
Yeah, my name is Will Constantine, and I'm the attorney representing the homeowners that have made these proposals. So I'd like to thank the city council for all the time that's been put into this. I'm not going to be addressing any of the legal arguments right now because I think they've been well looked at. But I would like to try to quickly get on some of the points that the city council had questions on. My experience with these ordinances is that I represent the city of Watsonville with implementing these, and down with the city of Marina, I've represented the homeowners down there going through 3 petitions. So we've had 4 petitions that have gone through this process and gone up to the OHA. And what I can tell you that it's worked as a whole, but I think that you've seen that from your votes on this. One thing in particular that I want to address is the settlement provisions really do work on this. And the key is you really need a carrot and a stick to put pressure on both sides. And I have personally put pressure on my clients either when I was representing the homeowners directly or when I was representing the city and facilitating a back and forth between the attorney from the homeowners and the attorney from the park owners. And it works. What happens is when you have a carrot and stick approach like this, both sides behave reasonably and you do away with extreme positions being taken, and in the end it saves everybody money. We haven't had any problems with homeowners having an election to elect our homeowners representative, and that's designated and submitted to the city, and the city knows who gets to speak for the homeowners for the settlement purposes. This was never intended to have one representative for the homeowners to speak for the homeowners on everything. The homeowners still have a right to go to a city council meeting, to give their individual opinions about anything that has to do with mobile home living or mobile home rent control. What this does is it enables the process to be facilitated when the homeowners and the park owners start negotiating. And what happens is a lot of times there's not just 1 or 2 offers, but sometimes there's 5 or 6 going back and forth at a pretty fast pace. The homeowners representative usually does go back to get a vote of the homeowners, but they decide how to do that and on what issues to do it. Obviously, and this is all from my experience, I'm talking with what the homeowners have done. If it's trying to decide between a $40 rent increase and a $60 rent increase, they're going to want to go back at that stage and make sure that people who voted them as homeowners representative are willing to agree with the number that they're recommending. Later on in the negotiation, sometimes things get a little bit nitpicky, as they always do. And at that point, if it comes down to an issue between a 7% interest rate and a 6.5% interest rate, and everything else is settled, you don't want that representative to have to go back and get a vote each time. And I have faced that, where both myself and the park owner's attorney, when I was representing the homeowners, were able to fight over these issues, come to an agreement where we had to get the homeowner's representative to make 5 or 6 or 7 different choices really fast. And within a matter of 4 days, we were able to settle one of these things with only really having one vote of the homeowners. And so we leave that up to the homeowners and their HOA to decide on that. As far as the conflict of interest, I agree with that, but what it should be is the homeowners should be able to elect whoever they want to represent them. It's their voice. The park owner gets to decide who represents him. The homeowner should have that same ability. Who has a financial interest that would be different and contrary to the rest of the homeowners. For example, if the homeowner's representative was a employee of the park, you wouldn't want something like that to happen. Or if the homeowner's representative was an employee of a mobile home dealer or some kind of outside economic interest, that's what you want to take care of. But you don't want to tie the homeowner's representative, and you certainly that person because of their association with an organization like GSMOL or anything like that. They have a right to get to choose. We don't tell the park owners that they can't have an attorney come and represent them that's a member of or associated with WMA, so it shouldn't be anything that nitpicky. It should be something to make sure that that person has the same honest financial interest of the homeowners, and then you just let the homeowners decide that. And it has worked. In Marina, 3 of these went to the OHA. After an initial decision, all 3 of them were settled. We had to do that pretty quickly, and it worked. In Watsonville, it was settled after it went up to the OHA and then to the Superior Court challenged it. The Superior Court upheld the basic substantive decisions of the OHA, but they said to go back down and do it again, have a hearing again exactly the way the OHA decided it as far as the substantive issues. The park owner asked that the OHA be removed. The court disagreed strongly with that and gave a 100% endorsement for keeping it with the OHA. And then right after that, we were able to settle it. I was representing the city at that point, and what I found myself doing was facilitating the negotiations between the park owner's attorney and the homeowner's attorney by just offering to both of them what I would think was reasonable at certain points with what they were suggesting to me, and then they were permitted to go and file whatever sealed offers they wanted to, but they both utilized me to give my opinion on things, and it worked. So those those provisions really work fine. That's been my experience with it. I know a lot of rent control ordinances don't have a provision like this. It's new, but it works, and it's just sensible. The other thing that I want to say is I think one of the reasons why this has gone so quickly through your process is, although this is recommended by the homeowners, it's not a homeowner's recommendation. It comes from the city of Marina after it went through this whole process already. Originally, it came out of most of Watsonville's experience, and then most of it, some of it was codified in Watsonville's ordinance, but some of it was just their procedures, their informal procedures, and then later on it was codified in Marina. But I think it's a fair and balanced process that's going to save everybody time and money. And, I congratulate you for so far going through this in a pretty expeditious way.
And you're at 7.5 minutes, so halfway through your time if you're curious.
Great. Thank you.
Could we have the attorney for the park owners? And I'm allowing 15 minutes. How long will you be?
I'm not sure, Mayor, but I do want to clarify that I'm only here today on behalf of DMV and the Moon Valley Park. which is why I think was the impetus for Mr. Moser's comment earlier as to why we need more time.
And I'm only going to allow, can you hear? You have to speak a little bit closer to the microphone. And I'm only going to allow one rebuttal, period, so we don't go back and forth, back and forth. Does city attorney agree with that logic?
Yes, and I'm assuming the 15 minutes you granted to the park owners is a combined 15 minutes. All three of them
Yes.
combined get 15. They don't each get 15.
No, it's a combined 15 minutes.
All right, thank you.
Thank you very much for allowing me to speak today. I do think the tenants here are leading the city down a very dangerous path. Sure, it's Brad Usum with Jenner & Block, and I'm here for DMV, which is the owner of the Moon Valley Park. I believe the tenants here are leading the city down a very dangerous path here today. This ordinance, we went over this last time, but only 20% of the jurisdictions in California have a rent control law. The city's law as it stands right now is already one of the more onerous laws on the books for a number of reasons, including the 80% CPI provision, the cap provision, no minimum rent increase provision, the 80% of NOI and so forth, and as well as the vacancy control provision. These amendments that the tenants have proposed, which the city basically just rubber stamped, I think 14 out of 14, plus a 15th that was in the park owners section, but really it was proposed by the tenants, so it's 15 out of 15, is going to make this law much more onerous for a number of reasons and subject it to a constitutional attack. And I can guarantee you that if these amendments are all implemented, which the city appears intent on doing, a lawsuit will be coming from one or more of these park owners. It's just a fact. To go over, and there's no way I can go over all of these in 7.5 minutes or 5 minutes or whatever it is, and so I do direct the city and the council to our previous submissions as well as my comments at the last hearing. I did submit to the council a decision matrix with DMV's positions. I know that Ms. Gallion has received it because she mentioned it. I don't know if everyone else did. I have further copies of it if anyone would want one. Okay. A couple of things I want to highlight. First, on the vacancy control, obviously that's a big one here. I think it's really interesting to note that not a single, and just to be clear on what this is not a rent increase that would be charged to any person in this room. This is not what this is about. This is a rent increase that would be charged to the buyer, to a new person who comes into the park. Now you ask, why do the tenants want this? Why do they want to charge the next guy less? Why do they care? The reason why is if the rent increase is less, they are going to be able to sell their home for more. And this is what we talked about last time, which is the premium theory. The basic concept is that the rents in the park are way below market rents. And when the tenants go to sell their home, they're not only selling the home, which is just the physical building, they're selling also the right to receive below market rents in the future. And the park owners aren't allowed to charge for that value, but the tenants unfairly are able to. And so what they're doing, all you have here is a transfer of that value, which is bundled up, and it's just being given over to the existing tenants who sell it to the new guy in the form of an increased sales price of the home. So for example, you have a $10,000 home, these are depreciating assets, they have a blue book value, it's called NADA, N-A-D-A, and if it's worth $10,000 or $20,000, they're able to go sell that home for double, let's say. Now that double piece of it is the expected rent savings over the life of the tenancy in the park, and that belongs to the park owner. And so that's exactly why these homeowners here want the 5% versus the 10%, and it's actually very disingenuous, because when these people bought into the park, they received a 10% increase, which means they paid a lesser amount for their home than they would have paid if it were at 5%. Now, when these people are going to sell their home, they want to drop down to 5% so they can go sell their home for more and reap a larger premium, and I think that's just unfair. Another thing I want to mention here is is the 80% of the CPI versus 100% of the CPI. These are the annual rent increases that we're talking about here. Currently, they're 80%. We've proposed to increase it to 100%. As an initial matter, we're literally talking about $3 to $4 a month in a rent increase. That's the difference between the 80% and the 100%. Mr. Walters said inflation has been very low, historic lows for the last several years. I think it's at 2% or something. So you're talking about a couple dollars. In fact, it's less than the amount that the tenants want to pay you in the form of the supplemental fee to defend your ordinance for you. It's less than that, and they're objecting to it. The county of Sonoma allows 100% CPI increases. It's more, 100% CPI increases are the most, according to Ken Barr, who the tenants here have advocated to you, he supports 100%. The city of Marina, which is the model that Mr. Constantine keeps telling you guys about, they're 100% of the CPI increase. It's the most common one out there. In fact, it's so common that the tenants here, in a prior submission to the city a couple years ago, they advocated for 100% CPI increases annually. They later withdrew that and said, oh, I made a mistake, and I shouldn't have written that in there, and that was in a prior version of the amendment that we drafted. But they clearly know that that's the right thing to do, and because they proposed it in the past. And their own expert, Dr. Barr, he advocates it as well. Fee shifting and the expert costs. These are clearly unconstitutional. What these do, requiring the park owner to pay for the expert cost that the city incurs, as well as this concept of fee shifting, requiring a park owner to pay if they lose a rent increase petition, all that does is discourage a park owner from applying for a rent increase. If you know, and let's talk about the expert cost. It's not $1,000, it's not $2,000. One that I recently did was $30,000, and that's just for one expert. This amendment that the tenants have proposed, it contemplates multiple experts potentially. So you're talking, this could be a huge number, tens of thousands of dollars that the park owners would have to pay just as a condition to filing a rent increase and having it heard. That's going to discourage them. In constitutional parlance, that means it's going to chill them from exercising their constitutional rights. Additionally, when you file a rent increase petition and potentially if you lose, you're going to get stuck with the other side's attorney's fees, that's also going to be chilling, and that's unconstitutional. That's under the Santee case and the California teachers case that Mr. Walter mentioned. The facts are very similar to that case. A person was applying, and if they lost, they had to pay a penalty. That's exactly what this is. It's a penalty. The rent increase. The rent increase process I want to talk about for a second, and this is in the letter I sent you guys last week. We all agreed that this rent board needed to be disbanded, and it sounds like on the tenants' proposed amendment, the city is going to do that. What we propose, what DMV proposes, though, is a one-step process. We've done additional research on the OAH as an initial matter, and as far as we know, there's only one city that actually uses the OAH for rent increase petitions, and I believe that's that's only Marina. Watsonville doesn't even have it. Their ordinance specifies the AAA. Now they may have used it before, but it specifies the AAA. And we're only aware of one petition that's ever gone before the OAH, and that was, in that case, there was a writ overturning the decision of the OAH because they improperly applied the MNOI provisions of that ordinance. What we propose is the city having a stable of 3 neutral experts that actually have experience with these issues and who are knowledgeable. It can give a fair decision and don't have to get up to speed every time. And then each time a park owner files a petition, both the tenants and the park owner have the right to strike one of those 3 people, and the person who isn't struck is left over, and they would decide the petition. And we propose it to be one step, not only to avoid the administrative burden on the city and just make it a more efficient process, but also because it would cut out the expert issue that we object to and that we believe is unconstitutional and ripe for a constitutional challenge.
So I don't break your thought, but you're right at 9 minutes.
Thank you.
Yes.
They have 5 minutes.
Yeah, you got 1 minute.
You got it, Dean. Let me just check my notes to see if there were any other questions that y'all had.
And issue number 8, just so you know, after this, we're going to be asking council questions, and that
Sure,
won't count for
sure,
you.
sure. And I would ask for a vote on the rent increase process that we proposed in my letter of September 30 and that I just went through. I think that would be an appropriate thing to do. I'll just reserve and let Dean go ahead right now.
Okay. Could you state your name and your address?
And my name is Dean Moser. I represent Pueblo Serena Mobile Home Park. I'd like to state first that this method of going through the ordinance is really speedy because you've given really very limited time to the park owners. I know that the residents have had opportunities to talk with you before, but we had 30 minutes last time and a couple minutes this time, 5 minutes this time. What I really want to talk
up just a little bit?
What I really want to talk about is vacancy control. I know that Brad already hit that, but it's a very, very important issue. At this point, just to give you some basis, the Pueblo Serena had a rent appraisal showing the market rent of Pueblo Serena spaces at $800. Adjusted under the city's ordinance, that was done in 2009. Today, that rent would be $896. Pueblo rents has as low as $381 rents, okay? A 10% increase on turnover for this space would produce a new rent of $420. Okay, that's 47% of what the fair market value of that space is. Right? One of the things that Brad pointed out is people buy a home in a mobile home park based on their cash flow. Okay? That cash flow has to cover their mortgage and it has to cover their rent. If the rent is low, then the mortgage can be higher. If the mortgage is higher, that means they can pay more for the home. If they pay more for the home, the person who is selling the home leaves Sonoma. That leaves the low rent at Pueblo Serena or the Sonoma Mobile Home Park with a lower rent that has to cover all of the expenses, and we're trying to maintain these parks so that it keeps the overall value of all of the other people in the park. It keeps the value of their homes up, because if the park isn't kept in great shape, then of course the value of everybody goes down. So what happens in this kind of a vacancy control situation is that the person selling takes the money, leaves town, the park owner ends up having to maintain the space to retain the value for the other people with not enough money. And the upgrades, any upgrades that are needed, then we end up, if we don't have the funds because the rents are too low, the people who need improvements or upgrades, we have to go through the process for improvements or upgrades, when if we had a proper rent, we might not have to do that type of thing. So I think what you need to do is to really take a look at this vacancy control issue. At 5%, I'd get a $15 increase. We're already getting only 2% rent increases at this time, which are in the $6 and $7 range. So we would like you to look at that issue again, if you don't mind, okay? And we can take the rest of my time for Brad on rebuttal. Thank you.
Okay, thank you. And that was 3.5 minutes. So you're at 12 and a half.
Okay, just a couple other points that I had forgotten as I went through my notes. Going back to the fee shifting provision, the whole concept of a settlement doesn't really make sense in the context of this ordinance. where it might make sense is if a park owner were entitled to apply for a rent increase in whatever amount it wanted. It would say, look, I think I'm $600 or $700 below market rent, I'm going to ask for a $700 rent increase. This ordinance doesn't allow you to do that. So in that situation, you can see a negotiation. This doesn't allow you to do that. The rent increases are completely formulaic. It's this MNOI increase. All you do is you're gonna set what the NOI means. What are your revenues? What are your operating expenses? And you're gonna come up with what your NOI is, your net operating income. And then you're just gonna grow it from 1992, and you're gonna see if it keeps up with 100% of the CPI. That's it. There's no real room for settlement. Either you're entitled to that amount or you're not. There's really no discretion involved here. So just this whole idea of a settlement doesn't make sense in our view. In addition, I want to just clarify, this is on number 2 of the homeowners' proposed amendments, which the city voted 5-0 in favor of, or the council voted 5-0 in favor of. I want to make clear that the tenants' proposed amendments, they don't apply to the capital pass-through. And I don't know if the city council here voted to make that the expert cost provision applicable to capital pass-throughs or just the fair return, the MNOI increase provisions. But I just want to be clear that the tenants did not propose it as being part of the capital expenditure pass-through provisions. And I'd like clarity on whether the council is going beyond what the tenants proposed and making it applicable to both the capital pass-through and the fair return provisions. I'll reserve the rest of my time.
You'll have a half a minute on that side, and we have 30 seconds on the park owners, and we have 7.5 minutes left for the attorney of the homeowners.
I'll try to make this quick. I mean, I hate to say this, but I was a little shocked back there, and we have to talk about credibility. As I explained, I'm the city attorney for Watsonville for doing these types of petitions, and I've explained what my experience was. Now, he just went over there and took a case that I handled and went to court on and told you the results of it were completely different. First of all, he said only one city uses the OHA. That's not true. Watsonville and Marina does. I know that. He said the same thing in his letter, and I sent you the documentation on that. He said that the OHA's decision was overturned. That's not true. It was upheld. He said it was overturned because the judge didn't like the way they handled their MNOI formula. Specifically, both the OHA and then the Superior Court judge on that very issue said that the city and the OHA were entirely right on the MNOI issue. So, I mean, it just flies in the face of reality for somebody to come up here and then start talking about cases that I was involved in and completely turn them on their head. He did that in the letter that he sent to you. I sent you the documentation to prove otherwise, and I think this just destroys the credibility of everything that he's saying. It's just shocking. He also said...
no clapping, please.
That you have one of the most stringent ordinances in the state because you have this vacancy control, partial vacancy decontrol at 5%. Well, the report that we submitted that Dr. Ken Barr did showed that of these communities in Northern California that they looked at, 24 of them had full vacancy control. So how is it that you allow 5% where 24 other communities allow full vacancy control, they don't allow anything, that makes your ordinance much worse than theirs from a park owner's perspective? Only 5 had it at 10%, and 5 had it at full vacancy control. So there's 10 that, under his way of looking at things, give the park owners more, and 24 that give the park owners less. So I don't think it's that you have the worst ordinance in the state, even from their perspective. He also mentioned that the expert witness cost that he hired at $30,000. That's why we do this. So it's not a battle of the park owner going out and hiring 2 or 3 experts at $30,000, the homeowners having no money to compete with that, and then you're having self-interested experts on both sides come in with figures that you're going to have to decide over, when what's more fair is to have an expert that's independent come in, analyze it on behalf of the city, and come in with a figure that both sides could look at. That's how we've settled all these cases, because the homeowners, in the cases that I've described before, they didn't want to give anything, okay? But when they saw that the city's independent expert recommended, hey, you may not want to pay more in rent, but we think that the park owner's entitled to $35, and when the park owner's asking for $100, and then the homeowners go like, okay, well, we're willing to settle at 40, it works, and it's a fair system. The other thing too is when he was attacking the OHA and suggesting that you set up a stable of local hearing officers. That's the very thing that in the Hash decision, the Supreme Court warned cities against doing, because what happens is when you have a stable of local hearing officers, the park owners and other interests that would be opposed to their decisions, what they're going to complain about is that they're politically influenced. Yet on the other hand, what the Supreme Court has ruled with state agencies, they were arguing the same thing. But the fact that the state has the Office of Administrative Hearings that's independent of any of the agencies that have to refer their appeals to them insulates them for those types of claims of bias, because they are, their continued employment does not rely on the type of decisions that they give pleasing the agency or the city that's hiring them. Instead, it's an independent agency where there's no interest like that, and the California Supreme Court said that. Also, the thing about vacancy decontrol in the premium theory, as it's been gone over again and again in all the briefs, the courts have rejected their point of view on it. And it's fair, because it's not just the blue book value of the coaches. When a homeowner buys a home, he buys it at the in-place value. When a park owner buys a park, he buys it at what it costs either at the beginning to construct the park or how much rent those spaces are bringing in. Studies have shown when a park is first constructed, for every dollar that the park owner puts in, for buying the land, leveling it, putting those spaces in, he relies on $3 for the homeowner's investment for buying the home, doing the landscaping, and doing everything else. So it's really a co-investment. And so what this does, it just properly splits the in-place value of the coach between the homeowner and the park owner by allowing the park owner to get legitimate rent increases based on that original investment, and allowing the homeowners to reap a fair return when they go to sell their home based on their original investment going back in time to previous owners. And it also has been shown that it does result in keeping the prices affordable.
Thank you. So we have I always feel this timekeeping, but we have to stay with the, so there's a half a minute left. How do you two want to share that?
Brad can take the half a minute. I wrote this, I'd like to give to Gay to give to you folks later.
Great, I appreciate that.
Okay, let's talk about credibility. City of Watsonville Ordinance 11-3.515. All disputes arising out of the city manager's interpretation and enforcement of the provisions of this chapter may be resolved by mandatory binding arbitrations pursuant to the commercial arbitration rules of the American Arbitration Association, unless all parties agree otherwise. I guarantee you that if you search through this document, you will not see the words Office of Administrative Hearings. On the writ, this is what it says. The decision, the peremptory writ of mandate, the decision of the arbitrator is set aside, including the award of legal fees. The arbitrator is ordered to reconsider the application and apply the MNOI methodology, including evidence of the appropriate base year adjustment using MNOI presented by any party. Pretty clear.
Thank you. So we are done with the two. So I'm going to bring it back to council at this point and talk about any discussion on any decisions that we made, unless the council is ready to look at issue number 8. Councilmember Hunley.
Pass.
Does anyone have any other questions besides issue 8? City Attorney, are you ready for issue number 8?
This on the last page?
Yes.
Well, I must say, I was disappointed that Mr. Yassine didn't enlighten us as to what the purpose of that proposal was. I
was asked, I did say that we would discuss that. I left that out of the 15 minutes for both.
Oh, you did?
Yes.
All right. I'm mistaken then. Why don't we ask him what 8 means?
If you want to come up, we'll give you 3 minutes.
I think it's a fairly simple concept. Under the ordinance, there are 2 forms of capital improvements. One is what they call a necessary capital improvement, and the other is called an upgrade capital improvement. A necessary capital improvement, by its terms, is necessary. The idea here is that, I'm sorry, is this the wrong one? I'm sorry, number 8 you said?
Yes.
Can you tell me, remind me which one is 8?
Add a section that would allow park owners to pass through to homeowners.
I'm sorry, I was addressing the wrong one. Number 8, so the idea here is if the park owners and the homeowners agree that a particular capital improvement or whatever, if they want a new swimming pool in the park and they agree on it, there shouldn't be a process that the park owner has to go through to put that new pool in and get reimbursed from the tenants. If it's agreed to, it's agreed to. We already have a provision in this in the amendment that the City Council has adopted that's going to have a homeowner representative who's designated by the homeowners to negotiate on their behalf and to bind them, and there's that should be equally applicable to this number 8. If everyone agrees on it, why should you have to go through a process? I think it's just really common sense, and that's all it's getting at.
Okay, thank you. Would the homeowners want to allow 3 minutes, but I do want to err on caution that we have to close at 6, and we do have some public comment, which we may be able.
You know, in essence, the ordinance already has this in reverse, because if the park owner decides to build a new swimming pool and submits it as a capital improvement pass-through, the residents have to get 50% plus 1 to oppose it. So I don't know what the difference is, but the way he has it proposed, one problem is going to be if the park owner gets these majorities of homeowners to come up with all kinds of luxury items to be added to a mobile home park, it could result, and I put this in my last letter to you, in slowly the parks being converted from providing low and moderate income into more upscale parks, which are no longer affordable. And it may be that it just slowly removes the affordable housing from the mobile home parks in the city.
Thank you. Does any of my colleagues on the council have any questions on number 8, or the city attorney have anything? At this point, should we just pass on this one for more information, or would you like to go ahead and, do you want to do a straw vote?
Okay, let's do a straw vote. I think.
No. No. No.
No.
And I also will be voting no on this. With that, is there any other discussion of the council members on anything on the matrix or any decisions we've made? Seeing none, we're going to go ahead and open up public comment. I will allow 2 minutes. And as I said, we are going to close at 6, so I apologize for those that aren't able to speak. Please come to the microphone and state your name and address.
My name is Gary Hermes. I live at 12 Ramon in Rancho de Sonoma. And just to piggyback on that last one, Rancho de Sonoma is being gentrified. We've lost 40 of our 99 spaces, at least 40. They are now owned by the park owner and being rented out at market rate, so just to be aware of that. But mainly I'm here to thank you for all the time that you've been spending on this. I know you've been bombarded by paper from both sides for a long time, and you inherited this from a previous council, and we just so appreciate the time that you've spent on this, and we just want you to know that we're always available to answer questions. We feel that this ordinance is a fair one for all parties concerned, and we know you'll do your best to give us an ordinance that Sonoma can be proud of. Thank you.
Thank you.
Linda E. DeVincent, 65 Guadalajara. I wanted to just touch on the premium theory. Mr. Newsom thinks that the only reason we would object to that vacancy increase is because we wouldn't sell our homes for as much money. But sure, I think that's reasonable, whether you're a homeowner on the east side or a homeowner on the west side. Why shouldn't we be able to enjoy a little bit of return on the tens of thousands of dollars we invest in maintenance, since we are homeowners? But the other thing is that we care about who's going to come into our community. We want them to be able to have the same fair opportunities that we've had, because we care about each other. We're a community, and we take our sick neighbor's soup and we have pancakes on Mondays, and that's the highest value to us. Thank you.
Thank you.
My name is Carol Tate, T-A-I-T. I live at 64 Guadalajara in Pueblo Serena. We've heard a lot about MNOI, NOI, lawyer talk. Now it's time for some clarification. I want to know why the replacement of a water system, not the replacement, but the repair of, is considered an improvement and not maintenance. Why is
If you could address the mayor, not the audience,
Okay,
please.
I'm sorry. Why is the maintenance of a sewer system and our water system and any electrical system not considered maintenance? It's not a capital improvement, and therefore it's maintaining an existing system that was put in when the park was built. I'm sure that MCA has lots of corporate CPAs that know all about reserve funds, life expectancy. There's actuaries out there that will tell you everything has a life expectancy. Plants, everything. And so when they know that life expectancy, they should be putting money aside for the eventual collapse of that system and the repair of it. And it should not be put through to the homeowners as a pass-through. Thank you very much.
Thank you.
Good afternoon. My name is Deborah Nitasaka. I live in Glen Ellen, and I'm here today representing the Sonoma County Housing Advocacy Group. I want to turn your attention to Assembly Bill number 225, just passed this last session. You can find the announcement for it on the Housing and Community Development website. This concerns modifications governing the Mobile Home Park Rehabilitation and Purchase Fund, formerly known as the Mobile Home Park Resident Ownership Program. There's funding here to cover capital improvements. I would like to see you tweak what you've done, which I think is so far really wonderful, by the way, but just tweak it a little bit so that instead of imposing repayment of the capital improvement costs, instead of leaving that to the homeowners to repay, I'd like to see language here that requires the park owners to first turn to grants such as can be found through this AB 225. Fantastic resource. They really should be required to look there first. Also, I really want to commend you because what you're doing here is preserving valuable, affordable housing, which, as we all know, is in very, very short supply across the nation as well as California. California, by the way, is the most impoverished state in the union. So anything that we can do to help homeowners, especially those in need of affordable, lower-cost housing, it's really incumbent upon all of us to do what we can, and I really highly commend you for all that you're doing here today. Thank you.
Thank you.
Gina Kuklis, neighbor up the highway from Boys Hot Springs. I'm here today because affordable housing and the housing crisis knows no boundaries in our valley and our county. And I'm asking you, keep your resolve. Do not give in to the threats. Keep your resolve. Because this isn't just about Sonoma and this rent control ordinance. This is about trying to break mobile home park rent control ordinances community by community. So keep your resolve, keep your backbone, and keep the course you're on. Thank you.
Thank you.
Phil Taylor from HCA Management. We operate Pueblo Serena. The goal of most rent control ordinances is the maintenance of affordable housing and unreasonable rent increases. I'd argue that we already have affordable housing in place, and the ordinance that's been in place in Sonoma has been operating correctly for quite some time. In the last 3 years, apartment rents in the general area have gone up approximately 30%. In the last 7 years, rents at Pueblo Serena have gone up approximately 11.5%, only a third. Additionally, as Dean Moser mentioned earlier, the average increase over a 7-year period has been $6.25. In today's world, that's almost nothing. The affordability of the community has been in place and working. One of the arguments that is often raised in terms of the need for affordability and protection for mobile homeowners is that they're kind of an in-place entity. They can't move easily the way apartment owners can move. But I think you ought to look at that avenue as opposed to other avenues of housing that are in place. Condominiums in the Sonoma area have an average homeowner's fee of $368 a month. As a matter of fact, if you combined the cost of the mortgage and rent in a mobile home park, it is approximately half of what a condominium owner would have. So both having the ability to sell their property and move forward. I'd also like to suggest that you really take another look at the vacancy control issue. Vacancy control works for the first person through the door. Every person after that sells that low rent to the next person as a premium on their house.
Thank you.
I think it's still afternoon. Doug Johnson with the Western Manufactured Housing Communities Association. We represent the owners and operators of mobile home communities throughout California. I've been with the association for 19 years. I've never quite seen a process like this. I don't know about you, but my head is spinning from listening to all the lawyers. Alameda County is currently going through a review of their 25-year rent control ordinance. It started in February, and during that time, we have had 8 public hearings, 8, before a group like this where we are limited to 2 or 3 minutes. But we've also had 6 two-hour stakeholder meetings where everyone who would be impacted by the changes you're considering are able to sit around a table and go through these items line by line, kind of the way you did this with lawyers today. There are so many voices out there, including mine. I consider myself an expert. I'm not a lawyer. Yes, I advocate for the park owners. I'm opposed to rent control. But I think my voice is just as important as hearing from the lawyers. Mr. Constantine, I was involved for 10 years in Marina fighting that rent control ordinance. He makes it sound like it's, a kumbaya, everyone loves it. They don't. The park owners do not like that ordinance. And if you can tell in my voice, I am a little disappointed that we haven't had the chance in this city for average folks from whatever agency or association or public or private, they haven't been given the opportunity to sit with you as council members or your staff to go through this issue. Your own city attorney started this conversation, but it wasn't a conversation. It really was a monologue by a bunch of lawyers. He said this is a very complicated issue, and I absolutely agree. We need to sit down and talk about these things, go through these issues. I mean, I heard clarification, more definition, more illumination. When do we get to add our points to it? Thank you.
And I don't mean to be abrupt, but we have a time limit here.
Good afternoon. I'm Bonnie Joy Coslan, 251 Del Rio Paseo. I would like to commend council and staff for the conduction of this meeting. We were all able to hear one another, and I would just like to remind you several weeks ago at a public comment session, I introduced and I discussed my own situation with the windfall profit and premiums, giving the history of the acquisition of my home. And at the time that I sold it, the windfall profit was actually a negative $1,800. So there was no premium and no windfall. Thank you.
Thank you.
My name's Jamie Peckham, and I live at 54 Guadalajara in Pueblo Serrata. And this is my first council meeting, and I've been very impressed. I think you're doing a stupendous job. I'm a little overwhelmed myself. One thing I did want to say is that I really commend you for hanging there with the vacancy control, because what seems to have gotten lost here is that we're talking about people on fixed incomes. Okay, we're talking about people on fixed incomes. I don't know about anybody else, but I think Social Security, if you're lucky, you get 3% a year. And the other thing is, at the 10% or the 5% when somebody moves out, that goes in the pocket of the landowner. So I think it's fair to say that they're getting more than, what am I trying to say is that they're getting an increase every time somebody moves, more than what my Social Security increase is going to be or what someone else's is. So we need to protect housing for disabled people and seniors. Thank you.
Thank you.
John Kyle, 14 Hacienda. I just want to say thank you. Thank you from the bottom of my heart. From the level of the conversation that I saw go on today, it's obvious that the council, the mayor, our city attorney, have all taken a good look at how complex an issue this was, and you took the time and made the effort to understand it and steer a course that's not only right for the homeowners, but also for the city and for the park owners too. This is a three-part project, and there are three players in it, and I feel everybody walks out of this room a winner today. And I want to thank you very much for all the effort. Thanks.
Thank you.
Hi, my name is Taras Lumiere. I'm at 113 Merida, and I love living in Sonoma. I've been here for 3 years, and you just can't squeeze more money out of us. Thank you very much for your support for affordable housing here. It's the last place I'm going to live, and I'm very, very happy to be here and seeing how much time and effort you're putting into this. And the idea that I'm going to make a profit selling this, my little place, for to somebody and being a fat cat is just a silly idea. So if you follow the money and go with your hearts, please support those of us who are on fixed incomes, those of us who are choosing to live and die in Sonoma. Thank you very much.
Thank you. And the council will allow one more public speaker.
Good afternoon. My name is Terry Poorman. I'm the vice president of GMSWell in this area. My area is from Oregon border to South San Jose. I go to a lot of these meetings, these housing meetings. In fact, I attended the one that he was talking about in Alameda. And it was, every one of these housing issues turn into a big circus like we have with all the park owners and their attorneys and their Giorgio Armani suits and their Gucci shoes, well, we have one attorney that represents the park residents. And unfortunately, the park owners have a lot of money, and so they can afford these big
Please
guys out of
address the mayor.
Chicago. And the point is that you guys have done a fabulous job. I've attended a lot of these about rent stabilization. You're analyzing it, you're thoroughly discussing it. The vice mayor, I have to give you a lot of honor and praise because you ask questions, and that's what it's all about. I hope that you realize that I too live in a mobile home, and the reason I live in a mobile home because it's affordable. You know, there are veterans, there are also people that are disabled, there are senior citizens. There are a lot of people that when these rents, like in Malibu, California, we know down at the Colony, they're selling for $1 million. Our little properties sell for maybe $100,000, $150,000, and they do depreciate. Thank you.
Thank you. With that, if there's no other council member questions or city staff, we will adjourn this meeting exactly at 6 o'clock.